said, Professor Alston is a professor at the New York University Law School. And among others, he also has been a UN Special Rapporteur on extreme poverty and human rights, as well as the UN Special Rapporteur on extrajudicial executions from 2004 to 2010. We are probably all familiar with the work of Professor Alston, but I would probably recommend to take a look at his newly open access textbook on international human rights law, as well as the edited volume that came out, I think, last year on the complexity of human rights. So it's very nice to have you with us, Professor Alston. And my name is Julia Emtseva, by the way. I'm a Max Weber fellow at the law faculty of the UI, and I'm joined by one and only Joyce De Coninck, who is also a Max Weber fellow at the UI. So we are conducting this interview in the following order. I will probably start with asking 3 questions, I mean, one by one, of course, which will be more about your work on private actors and privatization. And then I think Joyce will continue asking you about the overall, your overall human rights work. So all the questions will start with the letter P, as in Philip. And the first one is about private actors. So private actors have been the focus of your work since a long time. And your work has also shaped a lot of transformations in the field as well. So when reflecting on the current developments in the world, do you think that the urge to accommodate private actors in international legal frameworks became even more acute? And is there a way of how we, international lawyers, can finally curb unregulated private power? And maybe we can find questions in your new book on the complexity of human rights, where you speak about vernicularization of norms. That is to say that it's translation of the rights and norms to accommodate specific contexts of the or the social world. So maybe you would like to say something about that.
Sure. I mean, very interesting questions about the role of private actors in international law. We tend to sometimes see this as a more recent development, but obviously anyone who studied the history of international law will know about the founding of the British East India Company and the Dutch East Indies Company back in 1600 or so. The whole history of colonialism demonstrates the key role played by private actors, of course, with government support, but essentially, to the extent that international law was relevant, it was barely constraining and was highly enabling of what these private actors were doing. So this isn't a problem that's only arisen in recent decades. I think when we talk about the role of international lawyers, we obviously have to have some distinction between public and private international lawyers, because private international law is all about trying to facilitate private actors' roles. Public international law, on the other hand, if you come at it from a human rights perspective, then there's been a lot of effort to try to insist that private power should be subject to governmental authority in order to ensure respect for human rights. But those efforts have been very unsuccessful so far. The question is, how is that going to change? I don't think that efforts that are currently underway to draft a new business and human rights treaty are likely to be very successful. I'm also not particularly persuaded by a lot of the due diligence initiatives that are being put forward by the European Union and others in terms of their ability to really constrain the role of private actors. If we look at, say, the biggest challenge facing international law, which should surely be climate change, we see that despite all of the efforts that took place over the last 10 or 20 years, there is now a huge rollback on the part of private actors in terms of their commitment to lowering their carbon footprints and trying to achieve neutrality in terms of emissions and so on. It leaves us not all that optimistic about the ability of international law to really rein in private actors. I'm reminded, although this is a very pessimistic comment, I suppose, there was a very interesting book by a historian named Walter Scheidel called The Levelers, and he argued that the only times in which there has been a major leveling of economic and social well-being, in other words, increases in inequality and so on, have been either when the situation has involved major warfare, plagues, state collapse, or revolutions. And the implication of his analysis is that actors, particularly private, but also governmental, will continue towards inequality, and in the context of climate change, would continue to carry on with the activities that are leading us to a terrible outcome until such time as one of those events happens. So it may be that we have to wait a few years until the truly existential nature of climate change becomes apparent even to people like the Trump administration and their allies in so many other parts of the private sector who simply say that there cannot be constraints imposed by international law on what they do.
Right.
Sorry to be pessimistic.
You still have 5 more questions to
Okay.
divide
Okay.
the people. So the next big question is a question on privatization and your work on privatization. As a special rapporteur, you issued a few very powerful reports about the implications of privatization and the connections between privatization and human rights and international human rights frameworks. And I think it's hard to debate that it's not clear that the consequences of privatization are dire, and we should, we should pay more attention to them. But looking back at your work on this topic, is there anything you feel that international legal scholars misunderstood about privatization or about the consequences of privatization? And do you think international law has the capacity or the will to meaningfully address privatization, its consequences, its implications, especially when it comes to privatization of human rights and maybe also some of the governmental functions? Or do you think international law is inherently structured of not accommodating the things?
Well, I mean, I think privatization is proceeding very rapidly these days. I think one can understand most of what the Trump administration is doing, led by the president himself and Elon Musk, as forms of privatization designed to really reduce the power of the public sector, reduce the money available to the government, and to hugely empower private actors in every sector of American society. So privatization is an ever bigger challenge. I think other countries will start to follow some of the American moves, regrettably. I don't think international lawyers have really come to grips with privatization very much. There have been a number of significant works by different individuals, but international law in general has not focused on the specific and the quite particular challenges that are posed by privatization. I think that when you say, I think you said that the negative consequences are well known, I don't think that's actually the case. I think privatization, I think the neoliberals have won the ideological battle, which is to convince the public at large that privately run enterprises are more efficient, provide better services, are less corrupt, more innovative, and so on. I think the studies that I've seen, and not just that I've seen, the studies that are out there by economists and others do not support most of those claims. Most of them show that the private sector has not had all of those beneficial effects, but instead has raised costs, led to the exclusion of a great number of people from basic services, that profits have skyrocketed, and privatization is actually not a good recipe in a great many situations. But I don't think international lawyers have come around to that realization, and I see very few of them working on it. I think international law does have a key role, because if the sort of regulatory regimes that are needed are to succeed, it can only be, by definition, through international law, through international organizations that are set up, but which are not captured, like the International Seabed Authority, for example, largely by private interests. I think what's happening in space, in outer space, is another classic example where the private sector is operating with in the framework of an international law regime, which is not at all constraining or regulating effectively, but that at a certain point we will have no choice but to be trying to invoke the tools of international law to come to grips with that.
Right. So another interesting element of privatization, and this is our third P question, philanthropy. In your 2020 report as the UN Special Rapporteur on Extreme Poverty, you highlighted how philanthropy can entrench inequality by allowing mega-rich individuals to shape public policy basically without any democratic oversight. And also what we see now with this growing influence and the growing role of mega philanthropies in areas, especially as climate change and global health, with Bill Gates Foundation, etc. And also with this weird group of tech bros who are so deeply engaged in the public sphere in the United States. Do you see a way for international law to ensure that philanthropy or philanthropic influence is more transparent and accountable?
I mean, I have to say that I have, in some of my work, been a beneficiary of foundation support, and I'm very grateful for that. It's made a very big difference. But I am overall very negatively disposed towards the philanthropic sector. I think philanthropy is essentially a function of tax policy. It's the failure to tax the great fortunes that leads to the accumulation of such wealth. And it's the provision of tax deductions and exemptions that encourage individuals to give their money away. So it's a very artificial construct. And if we had effective and efficient and equitable tax systems, there wouldn't be these giant philanthropic foundations. The fact that there are, first of all, it certainly does distort. It's highly undemocratic because you've got a small group of people deciding where money is going to go. They take pressure off government by providing education or health services or whatever. They change the debate. There is no democratic accountability. So if you're unhappy with the education you're getting through a private philanthropy or the healthcare, there's not much you can do about it. You can vote all you like, but it won't change it. I think today, of course, we are seeing an even more tragic situation because the pressures that drove the big philanthropies to get together are now dissipating. And what I mean by that is that all of the big tech companies and all of the big billionaires attest to the capacity to avoid taxation almost entirely. Donald Trump as a businessman being the perfect illustration of that, but also all of the big tech companies that pay very low levels of taxation can abuse the system of offshoring onto Ireland or to wherever else, Luxembourg. And those, the philanthropies that result are going to be under much less pressure to actually serve the public interest. And I think we will see much more Elon Musk type, quote, philanthropy, which is essentially using vast amounts of money and power to promote a highly idiosyncratic, self-interested agenda. So I'm not optimistic at all about the role of philanthropy.
Thank you so much, Professor Alston. And I think now I'll pass on to Joyce.
4 more P questions. The first relating to planetary governance, the second relating to perspectives, third relating to plurality of actors, and finally pushing back against, or as human rights lawyers, against this dark turn that we're seeing.
Was it hard to squeeze all these issues into under the rubric of P?
We tried. Turning to planetary governance, in your opening chapter to your 2024 volume on the complexity of human rights, you note that oversimplification efforts or the decomplexification efforts within the human rights space fosters not only misconceptions about what the human rights regime is, but may also prevent the human rights regime from achieving its goals. Does your commitment to acknowledging the complexity of human rights coupled with the dependence of the effectiveness of many human rights on the habitability of our planet not require engaging with emerging scholarly, pedagogical, and political streams of planetary governance? Or alternatively, do you see or consider these projects as not pursuing sufficiently similar goals so as to engage with it?
Well, I have to admit, and maybe this just makes me an old fogey, that when I hear the term planetary governance, I'm a little bit taken to the realm of science fiction rather than international law. But having got over that initial reaction, there's no question, I think, that the major challenges that we confront, such as climate change, loss of biodiversity, and a range of other environmental developments in particular, can never be resolved unless we achieve more integrated and comprehensive approaches. And so it is true that more effective and more far-reaching forms of governance would be ideal. The problem, of course, is that there's a big disconnect between what's actually happening in practice and what we might assume would be required to have meaningful planetary governance. I think a lot of the academic studies that have been done so far under that rubric are very useful in pointing to the gaps, the fragmentation and so on that currently exists. But whether we can resolve those gaps under that rubric, under that heading, is less clear to me, because the risk is that it makes everything seem even less manageable, even more challenging, because we're trying to bring all of these different things together. I think the second part of your question, which is more human rights related though, raises this broader issue of the anthropocentrism of human rights. And I don't doubt that that is a major problem. Human rights are, or have been, all about humans, and for the most part, non-human animals and nature have been entirely neglected from the framework. Humans are being empowered, and it doesn't matter what they do to those other elements in the overall equation. I think that's a real problem. I don't think it's going to be easy to move from an anthropocentric understanding of human rights to a more ecocentric one. But obviously, not obviously, in my view, we have no choice because of what we're doing to the planet, which is rapid, full-scale destruction. And so a value framework that focuses only on human well-being and not on the broader planetary won't be adequate. But I still think we've got a long way to go in terms of focusing on the trade-offs that are going to be required on the part of human rights advocates and others, standards, regime, in order to accommodate a more balanced, ecocentric perspective. But it's clear that the human rights system cannot remain as it has been.
Thank you. And I shared with you the initial objections to the framing of it as planetary governance, but I have since been converted. You note something interesting. It's implicit in your answer about framing. And so that brings me to the second question. You note that a potential consequence of the decomplexification efforts in human rights is that theories of change will necessarily also be too simplistic. If we accept this, what are your thoughts on maybe not doing away, but letting go of the human rights framing as such? So as hinted at in a recent piece for Open Global Rights, what are your thoughts on unlearning or maybe letting go of certain vocabularies, frameworks, and methodologies that are central to the human rights regime in achieving similar or identical goals? So not to say going in the direction of planetary governance as such, but acknowledging that human rights as a complex set of regimes has given rise to a lot of capacity to divide rather than unite, and bearing that in mind, should we consider letting go of that framing and instead try to work towards something else?
I mean, I have a big problem, of course, because when we talk about a human rights framing, I strongly disagree with what might be termed the human rights framing, because I think that usually or almost invariably does not encompass economic, social, and cultural rights, for example. And so that framing is actually a very narrow one. It then leads to a narrow range of strategies built around legalization, litigation, naming and shaming, and other of the techniques that are well known to human rights lawyers in particular. And I don't think that that understanding of human rights or those strategies are going to resolve the major challenges that confront us. So my starting point is to say that the basic framework has to change. And once you change the framework, it becomes more obvious that the strategies and the approaches need to diversify dramatically. That this idea that you can simply call out governments, that you can issue reports saying that this government did this terrible thing and that government did that other terrible thing, that will suffice or will bring about real change. It's not proven, and it's highly unlikely in the future. I think we need to diversify enormously in terms of the techniques that are used, the groups and so on, and there needs to be a lot more flexibility. Now, I would still say, but this might lead to people calling me a human rights imperialist, I would still say that no matter what the social movement is or the techniques that are being used, there's got to be values underlying it. And we can talk, as you mentioned, or as the article mentioned, about an ethics of care or an ethics of solidarity and so on. I'm all in favor of that. But it is true that the only established ethical framework that has large-scale buy-in from governments, from a whole range of other actors, is the human rights framework. So I would still see that as being important and powerful, but it should by no means be hegemonic. I think there should be the more different approaches that can be used, the more likely we are to achieve the shared objectives we have.
Can I just push you a little bit on this answer and ask for you to elaborate on what you mean by diversifying approaches that we take to human rights? I understand the singular perspective on human rights that seems to be dominant in many academic jurisdictions or just jurisdictions generally, but I wonder what it is that you mean about diversifying the actors, the approaches, the methodologies, etc.
Well, I mean, one, I don't want to necessarily focus on this, but Julia mentioned before the concept of vernacularization that Sally Merry popularized along with others. I remember in days gone by attending training sessions, so-called, in developing countries where lawyers would get up and say, so you people need to focus on Article X of the Convention on Y. And it says as follows: states parties shall hereinafter recognize, and all this sort of legal language that actually meant nothing. And they would be told by these instructors that they need to understand human rights law and that these were the sources of it and so on. Now, Sally Merry's point about vernacularization is that you're going to get nowhere talking to most people in those terms. Yeah, if you've got an audience of international law scholars, that's great, go for it, bore them. But if you're trying to go out to a community group and you're talking about, I don't know, Sally did a lot of work on violence against women, to say, so Article 16 of the CEDAW Convention has been interpreted by various bodies, including special rapporteurs and the UN committee, as requiring that states, nonsense. It's not going to get you anywhere. You have to use the local language. You've got to say, you know, when the big man comes home, he, you know, cannot beat you. He lives like you according to the culture of your society, according to the religious traditions that you have and so on, as an equal part of the human family. And so there needs to be a big push in your community to change the values that are not consistent with those deeper values that you have. So the way in which you promote the message about violence against women is not through the invocation of international treaties or legal language, or even we can go to court on this. It's got to be much more a change of values. And I guess, you know, so that's a key element for me, is that we don't focus enough on the broader picture. And I think that then involves a huge array of different actors who are not lawyers, who are not court-centric, who are not talking about norms necessarily in the way that the human rights community does.
Thank you. Going further into this concept of vernacularization, that is to say the translation, as you said, of rights or norms to accommodate specific contexts or the social world, how does this process play out vis-a-vis human rights as they apply to non-state actors, but that are not private entities? And you know that I'm an EU scholar. Of course, I wonder how this plays out vis-a-vis the EU, but international organizations of this sort, or something akin to the EU. Can the same types of interlocutors be identified in calibrating, refining, and understanding human rights within a social reality that is characterized by other non-state public actors in positions of power? Are the actors in this social reality, so the duty bearers, the rights holders, the interlocutors, identical? Should the translation process accommodate the plurality of these actors, and if so, how? And are there challenges that arise in this emerging translation process that are not evident in the translation process as it applies to states? So essentially, I'm asking, how does this process of vernacularization play out vis-a-vis the EU? Does it play out differently? Are there different actors? Should there be different actors? How do we get to the point where EU citizens, for example, are made aware of the human rights violative potential conduct of EU entities, for example, as it plays out vis-a-vis people coming from outside of the European Union? And how do we entrench that in our values that underpin the European Union and how we govern?
I mean, I think the first part of your question highlighted the extent to which the state-centric international law framework has not been very effective in promoting the notion that human rights are really universal and apply to all actors. And so even the UN, for example, has had a very ambivalent relationship about whether human rights obligations apply to the United Nations itself, and has often behaved in a way that I think is abysmal on human rights, because they would say that formally we are not bound, we are not states, we haven't signed any of the treaties. I think international humanitarian law provides a much more interesting model where they have simply asserted that that IHL norms apply to all parties to conflicts. You don't need to have the formal consent through treaty ratification and so on. And I think that is a much more appropriate foundation. When you talk about vernacularizing rights in the EU context, I guess that's rather difficult, because the average, no, there is no such thing as the average EU lawyer, but people who study the EU from a legal perspective are going to vernacularize by focusing on EU and European instruments rather than on UN treaties and standards. And I don't have a problem with that, because I think there are various ways of trying to harmonize and so on. And by relying on formulas that Europeans themselves have drawn up and signed on to, I think that is one first step in vernacularization. But I think that the key issue really is the deeper issue of values. What are the values that are underpinning these rights? And I don't think we spend enough time insisting vis-a-vis institutions like the EU that it's not just the formal civil and political rights, for example, that need to be respected in a technical sense. It's rather the creation of a value-based society that reflects those broader values. And that's going to be, I think, very important in the debates in the years ahead, particularly around the issues that you mentioned, like immigration and so on.
And then maybe finally, as a matter of hope, Pushing back, how can the human rights regime resist decomplexification and offer nuance if the wider trend is to decomplexify? The political structures within which we operate are increasingly falling victim to decomplexification efforts in no limited means impacted by technology. So with this increased backlash against nuance and recognition of complexity, and including specifically in academic spheres, universities, and so forth, what are the factors that will help the human rights regime resist far-right and authoritarian turns? I obviously have some initial thoughts. I'll focus on one maybe because the other ones seem very obvious. One of the thoughts that I was having is that we don't consider human rights enough within the context of teaching. And I don't mean within university level classrooms. I'm talking about lower school, middle school, high school. We see human rights as this, or my sense has been that human rights has to operate quickly. And to me, this is more of a marathon than it is anything else. And if you don't start at value-based education at a young age, I don't see how we can expect university graduates to have that type of thinking embedded in their general rationales, whether they be lawyers or anything else.
Yeah, I mean, I strongly agree with that. Of course, it's not just university graduates in whom we want to inculcate the values. It's the citizenry at large. But I mean, I think we're on the same wavelength. As I said earlier, I think that, well, I think one of the things that is most depressing is that the proponents of neoliberal policies have actually won the values debates. And so the values that have been promoted, and this comes out in the privatization context, but in many others, are of individual autonomy, of a minimalist state that doesn't interfere, of me defining my freedom as my right to basically do whatever I want to, as long as I don't physically threaten my neighbor. And I think that is a total distortion of what we see as human rights values, which are based much more on compassion, on solidarity, on an ethics of care, on freedom, defined not as individual, I'll do what I damn well want to do, but freedom as interpreted as a broader society which enables all of its members to flourish. And I think that a lot of the work that's been done on human rights just ignores that values foundation and instead goes into, well, let me tell you about the jurisprudence surrounding the right not to be subjected to cruel, inhuman, and degrading torture or punishment. Unless you've got the underlying values there, it's not going to resonate. And I think implicit in your question is that what's called human rights education has been pretty disastrous. Again, promoted by organizations like UNESCO. You couldn't expect an intergovernmental organization to be doing anything meaningful about really trying to educate students on values. And I think that they have been highly unsuccessful. But I think one needs to see as one of the principal activities of anyone engaged in the human rights enterprise, to use that neutral broad term, the obligation to try to educate, to try to facilitate discussions about values within the communities that they're working with, instead of coming in and saying, listen, this is the value, it's stated in this treaty, you've got to do it. And the result is that human rights are seen quite separately from that deeper value debate. And it's true that you're never going to bring about real change within societies without that extensive level of societal change. Abdullahi and Naim who's a Sudanese scholar of Islam in particular, has long argued that unless the human rights values that you promote resonate with the local society, they're going to go nowhere. And I think that insight applies comprehensively. It's not just Islamic societies that you're talking to. And so we find ourselves, and perhaps I'm going over time here, but we find ourselves in the situation where a lot of conservatives will say, and this has been particularly true in the tabloid press in the United Kingdom, that human rights are basically to defend rapists, drug dealers, and other criminals, because the only time that I ever hear about human rights is when I'm told that this particular criminal shouldn't be badly treated or shouldn't be sentenced to a very long term in prison. But when I ask about my own well-being, human rights don't come up. Human rights groups don't come in to defend me, to try to make my life more fulfilling. And I think we really do need to address that. And that's a values debate which has been neglected.
Thank you.
Thank you so much, Professor Alston. It was a fantastic conversation that I hope we will continue in some form, whether you're writing, your lectures, or maybe our writing as aspiring
Yes,
scholars.
more importantly.
So thank you so much for joining us.
Thank you.